The civil procedure question from February of 1999 is enormously interesting and useful to have a look at. Here the examiners are testing one conventional issue in a rather unconventional way and one unconventional issue in a simple way. Take a look at the call of the question. Did the court correctly decide on W's motion? To 1, dismiss for lack of jurisdiction. Discuss. 2, dismiss on the grounds of forum nonconvenience. Discuss. Well, a lot of people don't even know what forum nonconvenience is, but you don't have to speak Latin to be able to figure it out. The party is moving for a dismissal on the ground that it is not convenient enough for them to be able to litigate the case. We'll have to have a look at the facts. With regard to jurisdiction, here we've got a basic checklist in our minds, which is enormously useful. But here, we've got to be a little flexible. We know that our traditional approach to state jurisdiction will involve a long-arm statute and minimum contacts, and that those minimum contacts include purposeful availment, foreseeability, and fairness. We also know about federal jurisdiction, either subject matter jurisdiction or diversity jurisdiction. And with diversity jurisdiction, we've got to have an amount in controversy requirement satisfied, and we have to have full diversity of citizenship. What is so interesting about this fact pattern is we've got to work in a minimum contacts analysis on a federal diversity issue. That is quite a novel way for the material to be tested. Let's go to the top of this fairly short and therefore somewhat threatening fact pattern and have a look. In paragraph 1, we find out about a contract from 1998. Park Company is a State X importer. They make a deal with Wholesaler, which is an Italian company that sells, in this case, a shipping container of vases for $800,000. Read carefully the description that is given in paragraph 1. Although the agreement was negotiated entirely in Italy, there is a non-binding arbitration clause requiring arbitration in State X before any action on the contract. What this tells us is the parties are foreseeing the possibility, at least, of a dispute, and they expect it to be resolved in State X. In paragraph 2, we find out a little bit of background information. Before entering into this contract, W, the wholesaler from Italy, had never done business with Park. They sell most of their goods in Spain. But a couple of years earlier, in 1996, W had sold material to another State X company, 3 shipping containers worth $700,000 each, a substantial amount of money. And the sales had been negotiated during a month-long sales trip to State X by W's president. Well, it looks like they're setting us up for a jurisdiction case about state court. But read on. In paragraph 3, Park rejects the 1998 container of vases on the ground that they did not conform, and under the UCC, he has the authority to do that. 2 months following an unsuccessful private arbitration in State X, Park sued W, but read carefully, in federal court in State X, alleging $100,000 in lost profits. W moved to dismiss on the ground that the court lacked jurisdiction, and on the alternative ground of forum nonconvenience. The court denied the motion in its entirety, and I think it's likely we're going to agree that that was appropriate. Next, we find out more facts. W's witnesses all are in Italy. Italian courts provide a forum for the plaintiff's claim, but Italian law recognizes fewer theories of liability and imposes a limitation on damages, which State X does not. So now we have a call of the question we've already had a look at. So we have a fairly simple and quite short fact pattern. We have to just keep our heads together, not panic, as many candidates did in response to this question, and figure it out, find a home for the facts, and write a simple, direct answer. And as it turns out, this is one of the easier and more straightforward Civ Pro essays of recent years. The first call of the question I respond to, now looking at the outline, with a conclusion in the heading that the court correctly denied the motion to dismiss for lack of jurisdiction. I focus on federal diversity, and I explain the diversity and amount in controversy. Next, I focus on personal jurisdiction, which in this context certainly will require minimum contacts and not offend basic notions of due process. Here's where I find a home for all of the facts that they are giving us about the relationship of the defendant company to State X. So I reach a conclusion which flows from the analysis. I agree with the court's dismissal. I think it was correct. Next, I focus on the nonconvenience issue. I define it briefly. I indicate briefly what the federal court's authority is and that the plaintiff's choice in venue is typically deferred to, before I reach a conclusion, again, supporting the one that I presented in the heading, which was the court's denial of the motion was correct. So, a pretty simple question, but an unconventional question, and a question that poses a couple of novel issues. So take a look at the answer, and here you'll see this is a very plain, very simple example of connecting the facts to elements of the analysis and arriving at specific conclusions that are responsive to the questions presented. So here, given the relative simplicity of the problem and the relative scarcity of issues, I take the time to find a home for every detail. Up front, in the very first paragraph of my answer, I explained the procedural context of the question. I explained the underlying lawsuit and the defendant's motion to dismiss. Then, I go into the details and the analysis. I focus on diversity of citizenship. And, for a change, I actually lead with a rule, a very short statement of what diversity jurisdiction in federal court requires. Next, I focus on those elements. Diversity is present. But here, what's interesting is we've got diversity of national citizenship rather than state citizenship, which is the typical and most commonly tested way of getting into federal court by diversity. Also, the amount in controversy requirement is met because the plaintiff is alleging $100,000 in lost profits. Next, we move on to the personal jurisdiction issue with regard to minimum contacts. And here, notice up front, my explanation, although not full of definitions, is very solidly grounded in the law. I'm explaining up front why it is that I feel that we need to do a minimum contacts analysis in a federal diversity jurisdiction question. And I go into the details. The underlying contract provided for non-binding arbitration in State X. That indicates that it was foreseeable to the parties that disputes would need to be considered, and they would be considered in State X, rather than in an Italian court. Next, I indicate, just following the facts more or less chronologically, that the defendant corporation had never dealt with this plaintiff before. But that, by itself, doesn't really mean anything, given the other contacts that the defendant company has had with State X. Then I go into those details. The defendant had a prior multi-million-dollar deal in State X. I find a home for the facts. I move on to the fact that the president of the defendant company had spent a month in State X on business. It's an important contact between the defendant corporation and State X. So, the exercise of jurisdiction under the totality of the circumstances appears to be entirely reasonable. Thus, I conclude that the court's denial of the motion to dismiss on jurisdictional grounds was proper. Next, we move on to the forum nonconvenience issue. And as you see, this is a much thinner issue than the jurisdiction argument was. There's a lot less to analyze. But still, we have the luxury of time in relative terms compared to other racehorse fact patterns, so let's have a look at just how much depth we really can get into. I lead with a heading on forum nonconvenience, and I focus on what that is. Basically, the defendant is arguing that even if technical jurisdiction requirements are met, it wouldn't be fair to require the defendant to contest this lawsuit in federal court in State X. And I note that the federal court doesn't have an obligation to exercise jurisdiction just because a plaintiff has met the technical requirements. If the court thinks it would be in the interest of justice for this case to proceed elsewhere, the court could decline jurisdiction. But, as I indicate in Section C, the plaintiff's choice of jurisdiction is deferred to. Here, I find a home for the facts about the differences in the cases as they would be heard in the two different courts. And in the conclusion, I go on to present more detail about why the plaintiff had very strong tactical reasons for wanting to be in federal court in state X, as opposed to being in the Italian courts that cap damages and limit the theories of liability. So, I conclude that the state X federal court correctly denied the defendant's motion to dismiss on the grounds of forum nonconvenience. So, let's take a step back. We have just had a look at a fairly tricky, but ultimately straightforward civil procedure problem. What makes this a tricky problem is they are combining jurisdiction issues from state and federal jurisdiction and presenting them to us in an international lawsuit context. But if you are sensitive to how this material is tested and appreciate why it is that many of the facts in this pattern would be there, you are able to fly by instruments, figure out what's really going on, and present an answer that is well organized, thorough, specific about the facts, and which provides reasoned and reasonable answers to the questions presented.